Happy Friday, everyone. Happy New Year. I hope everyone has had a good first 10 days of the year. So today we're talking about, again, I'm Fran McGovern. For those of you who don't know me, I recognize most of the faces, but there's a few probably newbies here, which is great. By the way, always please tell your friends, your board members, etc. Anyone can, even our competitors at times jump on these first Fridays with Fran. But please feel free to tell people they're welcome to come on. It's fine. You can give it to your board members, you give it to their managers. That's fine. The more the merrier. So I got to do a little announcement first. This is not legal advice. If you want legal advice, you have to go out and either hire us or hire an attorney and ask them, another attorney and ask them real legal questions on your particular facts. These are educational purposes only. Nothing will be maintained in confidentiality. But it is nice to see everyone. We're going to do dog of the day real quickly. So we have a dog of the day from Donna Hanna. Donna Hanna was one of the controllers. She was a controller at the Ritz over on the boardwalk in Atlantic City, and now she's a board member over at Huntington Run Condominium Association since she's retired from management. And these are Donna's two dogs. Louie Bo Rudy is the first one, and the other one is Lena Bella Bubbles. Very complicated names. Some really good grooming. Look at the grooming on those dogs. They are 3-year-old Sheranians, which I've been told are designer dogs that are a combination of a Shih Tzu and a Pomeranian. So very fancy, even more fancy than my dog, but very fancy dogs. Thanks, Donna. I don't know if you're on with us today, but very fancy dogs. Oh, there she is. Hey, Donna. So thank you very much for submitting Dog of the Day. And today's webinar was at special request of Terry Vigiano. I hope Terry's on with us today. I haven't seen her yet. To do a more or less kind of a quick refresher on contract issues, which is always a good thing. And the reason for that is people screw them up constantly. And or don't have attorneys review them. And even though you don't have to pay the attorney the $400 or whatever it is to review the contract, at the outset, so that in theory saves you $400. When the contracts go bad, you then wind up paying us $10,000 to fight over the contract issue, right? Which is, you don't want that, right? Even Jeff Schiffman, who loves lawyers, doesn't want to pay us 10 grand to fool around with a contract dispute, right, Jeff? Nice to see you. So this is a special request at Terry Vigiano. Footnote today, the beneficial ownership reporting is not required. It's stayed again. So you might remember that in the interim, when that was going back and forth, and you were getting all my annoying emails, it was put off to January 13th for a while there. But it is stayed. The January 13th deadline is not applicable. It is stayed right now until further order of the court. So just keep that in mind. I don't want to get into that any further today, but if you have a question, certainly afterward we can, but it is stayed. The January 13th deadline is also off. So we did the dog of the day, and now we're going to talk about different types of contracts. We have Crystal Ahern, by the way, with us today. She's one of our office administrators, and then Mike Palulak, who's one of the attorneys in the firm as well with us. But so the types of contracts, I did this kind of generally here. So we have high dollar, high risk contracts. What does that mean? That means big dollar contracts and big risk if things go bad. Where do you see just an example of those types of contracts? What would that be? That would be a high-rise facade type contract, right? So you're going to redo the facade. It's going to be a $12 million job. And by the way, if it's not done properly, people might get killed. The facade may fall off. You'll have all kinds of crazy water infiltration. So there's risk in terms of property, life, health, safety, damage, et cetera. So that's high dollar, high risk. What about low dollar, low risk? So sometimes when people are dealing with attorneys, they'll say, Fran, the contract's only $10,000. We're not going to get an attorney to look at it. It's a waste of money because it's only a $10,000 contract. So where is that a problem? If it's a low dollar contract, but it's a high risk contract, you still want an attorney involved. The reason for that is when I say high risk, so it may only cost, for example, $10,000 to replace certain window flashings, right? Certain window flashings. And it might be cheap, it might be a $10,000 contract. But if those window flashings aren't done properly and water seeps in behind the window flashings, you're going to destroy the interior structural members of your building, right? So you can have a relatively low dollar contract, but the actual work itself can cause significant risk to your structures. So that's low dollar but high risk. High dollar, low risk. What is the biggest high dollar, low risk? Is generally your landscaping. Generally speaking, you have a high dollar contract, but the risk of somebody, getting their lawn cut too short, or the radius of the lawnmower turning and creating ruts in the front lawns, that's not going to kill anybody. That's not going to destroy your whole lawn. So it's high dollar, lower risk. But since it's high dollar, obviously you want lawyers involved. Then there's low dollar, low risk. And what is that kind of stuff? And these are the ones that are often handled with work tickets rather than contracts. And usually the low dollar, low risks are often not handled by attorneys. Why? Because all you're doing is, replacing a piece of moldy drywall, that's only a, $2,500 job. It's not involving mold remediation. There's no real risk involved. Okay. Um, what do you want done? This is, I would say, in many respects, the most important part of the contract. What do you want done? Well, whatever they put in the contractor specifications, generally speaking, if it's a significant contract, you don't want to just go with the contractor specifications. You want a third party like an engineer, an architect, or a consultant um, to give you specifications so that you can go through an accurate bidding process and you can bid apples to apples. Okay, so it is money well spent to pay architects, engineers, and consultants to give you the detailed specifications so you get what you pay for. And we'll talk about that a little bit more in a second. You don't know what you don't know, but you're not stupid. Ask questions, right? So and this goes in my own firm here. An IT professional will come in and say, "Hey, Fran, this is what we're going to do. We're going to replace your system, and there's this, seat fee license, and it's only going to cost you about $75,000, and blah 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 blah, and everything's going to be great." I don't know very much about IT architecture, right, and how software works and how they should be priced and so forth. But that doesn't stop me from saying to an IT consultant, well, that really doesn't make sense for the following reasons. Our firm is different than all these other huge firms, or our firm is different from solo practitioner firms, right? So even though you hire professionals like architects and engineers, don't hesitate to ask questions. Two things. One, that's their job, is right to tell you about the job. Two, you're educated as a board member or a manager. Those people can educate you over the course of your career or tenure as board members or managers. I have learned tremendous amounts of information from architects and engineers, and I have no background in architecture or engineering other than that. So always ask questions. Request for proposals and bidding. So again, request for proposals and bidding, you should send your prepared specifications out with your request for proposal. This is what we want done. And say, this is what has to be included in your proposal. That way you have a uniform specification and you can put the bid side by side and say, bidder A, bidder B, bidder C, these are the prices, but are there proposals matching our specifications? I would say, and all the managers in the room can agree with me, I think it is extraordinary when competitive bidders actually come back with matching proposals. Almost never do they meet the exact specifications, and almost never are they exactly apples to apples. So more often than not, especially on significant jobs, the manager has to go back to the vendor and say, wait a second, this is really nice, but we asked you for this type of proposal and you gave us this, which is fine. We're not, throwing you out of consideration for this. But you have to revise your proposal to meet our specifications. There is no requirement. This comes up a lot. There is no requirement in community association world, unlike the public government world, of sealed bidding procedures, right? So there's a whole body of law in public government regarding sealed bidding procedures, not required at the association level, okay? The contract should, however, to become binding, be voted on in an open meeting, open to your membership, right? So they can be discussed, they can be negotiated in a closed session meeting, but they should still be voted on in an open meeting. Price versus value. Price versus value. This especially goes to the management company worlds, price versus value. There's a big difference between the concepts of price and value. Too often, associations go with the low price bidder on the management side. In my opinion, that is a big mistake. it makes lawyers rich. Okay, it makes lawyers rich because if you have weak management, you are going to have lots of legal issues. And those legal issues will inure to the benefit of the attorneys who wind up trying to deal with those legal issues. So as I say many times, if you try to cut a corner on management services and go with the low bid or cut rate management services, you're going to wind up giving the money back and probably even more to your legal vendor, right? So be very cautious in thinking about the difference between cost and value. And as I say to management companies all the time, management companies should be selling on value, not on price. They should be going into a meeting or a bid meeting with a board and saying, this is what we do for our communities. This is what we do. So when you compare us, you should be comparing us based on what we do, what the processes and procedures we have in the back office, what the personnel we have, what we have standing in the management community, in the management industry, versus, and there are people in this industry who do this, we will be the lowest per door bid, right? And we see this regularly. We're going to come in and we're going to give you the lowest per door bid. You have to know that either one of two things are going to happen. You're going to wind up with cut rate services, one, or often worse yet, you're going to wind up with a lot of a la carte dings after the fact, even though you feel you've locked in a management fee. And we get those phone calls as the lawyer. Hey, Fran, this is crazy. We have a management company that said they were going to do our job for $50,000 a year. And we look at the end of the year of expenditures and we've spent $175,000 on management. And then I go back and I look at the management agreement that they never sent us for review, and it says everything on there. The following services are a la carte, right? And that's what happens. A $50,000 management agreement turns into a $175,000 management agreement after the year. So you just got to be cautious about that. Board members don't always realize that the value of management versus the price of management. It's got to be really careful about that. And that goes with respect to all contracts. All contracts have the same value versus price dichotomy, but you got to look at both sides of the equation. Project management and financing work outside of the day-to-day management scope. So what does that mean? When you hire a management company to deal with your other vendors, if it's outside of the scope of their day-to-day affairs, such as snow removal, lawn cutting, etc., you want to do a new pergola, you want to re-roof the clubhouse, you want to re-side 30 buildings. That's not within the scope of most management agreements. So there's going to be a provision in there that says, hey, if the work is outside of the scope of the day-to-day management services, we're going to charge you a price to deal with that. Be very careful of that, right? You have to look at that in the management agreement, and you have to talk to your management company representatives as to how that will be paid, how much it will be, how much it will be in total, and what the expectations are on management during the period that they are administering outside the scope contracts. Okay, does that make sense? Because again, we are routinely called when a board goes out to do a significant project and they call up and they go, Fran, the management company is ripping us off. And I go, what do you mean? I know these people, they're not ripping you off. And they say, well, yeah, they're going to charge us X dollars to administer this contract. I go, okay, well, in their management agreement, it says this is the price. It's an outside the scope project. You know, day-to-day services does not include re-roofing 30 buildings. They're entitled to something. Is the issue with fairness? If there's an issue with fairness, we could talk about it. Most management companies we work with are more than happy to sit down and talk about that. But just keep in mind that if it is outside the scope of the day-to-day affairs in terms of administering contracts, there will generally be an additional charge for that. And that's normal, of course. Conflict of interest. So fully disclosed conflict of interest, board members, management representatives, et cetera. We do have a few boards where I have one board in particular, a very large association where one of the board members' sons is the snow removal vendor. She obviously doesn't participate in any of the discussions of snow removal. She doesn't participate in the vote on snow removal, has to be disclosed, can't participate in the vote. So disclosure, 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 and then recuse yourself from the discussion. The contractor's proposal. What is the key there? Do not sign it. do not sign the contractor's proposal unless it's a low value, low risk type contract. The reason for that is the proposal becomes a contract when you sign that line saying, I agree to the terms of the above, right? You then have a contract. And then what happens is you have a signed proposal and they call us and they say, hey, Fran, can you prepare a contract? And they send over the signed proposal. And we say, golly, you already have a contract because you signed this. Now, most of the industry vendors will say, Fran, we know they signed the proposal, but we'll go and negotiate a contract anyway. But it always hurts you to sign the proposal. So we advise against signing the proposal. Attorney contract preparation, the cost benefit, can't we just do it? So the attorney should prepare the contract, but at what cost? So that goes back to the value proposition at the top. If it's a low cost agreement with low risk agreement, like I said, oftentimes those things are done on work tickets, work orders, without a formal written contract. But anything outside the scope of that, you should really have an attorney prepare it. Keep in mind too, when you talk about what contracts have attorney preparation and how attorneys negotiate agreements in this industry, a lot has to do with the relationships of the parties, right?
Yep.
So, for example, on these Fridays with Fran, we see, and I know many of you are prominent managers in the field, right? Prominent managers in the field. Prominent managers in the field can bring very reputable vendors to the table. And generally speaking, if they bring a very reputable vendor to the table, that vendor wants to preserve the relationship with the well-known manager. That value of the well-known manager is huge, right? Because they generally won't torture us, meaning your lawyers, in negotiating the agreement. They're not going to worry about the period or the semicolon or paragraph 5 because they know the most important thing in their life is maintaining their relationship with Beth Duffy, right? Because if they can maintain a relationship with Beth Duffy or Jeff Schiffman or whoever else is on the call, I can't see right now, they want to maintain a relationship. Brian Aubrey, right? They want to maintain that relationship. So they're not going to torture us in contract preparation. They're going to say, Fran, we're fine with provisions that are very favorable to the association. We're not going to scrape over each individual contract provision because we know Brian's going to do the right thing. We know Beth's going to do the right thing. We know these people are going to do, Jeff's going to do the right thing. So just write it the way you want to write it, and that's fine. Where things get sticky is, and you've seen it with some pool vendors over the past couple of years, where they're either new people, new issues, or people who are generally not in the industry itself. So you have to be careful. And again, that's one of the other major reasons for dealing with a known entity and having a known management company. They have the relationships with vendors and can get them to do things in a way that is much easier and in many ways much more accountable than perhaps management companies who are operating out of the trunk of their car. So change orders, unit costs, and contingencies. In my own personal life, when I do contracts for home improvements and so forth, I don't want any change orders. I don't want any unit cost items. I don't want any contingency in the contract if I don't have to. Why? Because I want very detailed specifications. And I want that all built into the original contract. Vendors make a fortune on change orders, unit cost items, and contingency sums. Now, sometimes that's unavoidable. Basically, architects and engineers, for example, in a roof project, will always build in, say, a 10 or 20% contingency because they don't know what they're going to find under the roof shingles, right? You might have rotting sheathing, you might have various truss issues, et cetera. That's going to come up. But if you have good specifications, quality specifications, you should have that pretty tightened up in terms of a cost in a bid contract, right? You should say, hey, guy says change order, say, no. This is what we had in the specification. This is what we want. And that goes for the same. If anyone, I've never done this, but if anyone's built a new home, bought a new home, right? And then you go into the designer upgrade showroom, right? That's where people make their money, right? They sell you a spec house, but then they're selling you the marble deluxe quartz countertop for another 20 grand, right? So if you can avoid that in your projects for the association, avoid it. If you want the deluxe quartz countertop fancy schmancy stuff, that's fantastic. Put it in the original specification, right? Because keep in mind, if you, especially on a construction project, once you've married the contractor, right? You're married, the place is ripped apart, you're redoing the clubhouse, and they go, oh golly, we didn't think about that. We'd like to do a change order to put fancy marble tops on all the reception desks. You're not going to go out to bid for that $30,000 portion of the job, right? In a way, you're locked into that relationship and it makes it very awkward, okay? So make sure you spec it. Termination. How do we get out of this relationship, right? How do we get out of this relationship? That is a major provision in our contracts. Our contracts, we always want with or without cause at any time, with or without cause at any time. That's the best provision for the association, with or without cause at any time. Where do associations get themselves in trouble? When they agree to termination with cause. And a lot of boards say, Fran, why will we argue about that? What's the big deal? If they're doing a poor job, of course, we'll be able to terminate them. The problem with that is then you spend money on us arguing over, did they breach? Was there cause to terminate? Because the vendor will say, no, 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 everything was fine. Your board members are just being sticklers, or your management is just being sticklers. This is not fair. It's not reasonable, this and that. As many of you know, once the relationship goes sour, it's often very hard to bring that relationship back to a healthy relationship, right? That can happen over a period of time, but with a particular project, specific project, it can be very difficult. So we generally suggest that associations look for termination with or without cause. Um, if you can't get with or without cause, go with cause only, rather than with cause with a cure period. So there are a lot of vendors who will put in there that'll say, if we breach, you can only terminate with cause after you've given us 30 days to cure the breach. And if we cure the breach within the 30-day breach notice period, the contract is cured and you must keep us. The problem with that is that can go on and on and on, right? Breach, cure, breach, cure, breach, cure. So the best case in the world is termination with or without cause at any time. Insurance, additional insured versus proof of insurance. Proof of insurance is nice. You get the little thing, the proof of insurance certificate from the insurance company, but it basically means nothing because they can cancel their policy the next day. What in an ideal world is you want additional insured status so that you're actually made an additional insured and the association can make a direct claim against the vendor's policy in case there is a problem, somebody gets hurt, something is damaged, what have you. All right. Indemnification, defense, and hold harmless. This is an area where you have to speak to your attorney in terms of indemnification. Indemnification means the person agreeing to this will pay for any harm. Defense means the person agreeing to this will pay for any attorney fees. And hold harmless means the person agreeing to this will not go back against the other party for the damage or the attorney fees. So indemnify, defend, and hold harmless. Generally speaking, the association wants the vendor to indemnify, defend, and hold harmless the association. The association should not be indemnifying, defending, and holding harmless any vendor generally. It's a little different. In management agreements, the association does indemnify, defend, and hold harmless the managing agent to the extent they're acting within the scope of their job, right? Or direction from the board, right? So management agreements are a little different than other vendor agreements in this area in that the association does indemnify, defend, and hold them harmless. The other vendor agreements, the association generally should not be indemnifying, defending, and holding harmless anyway. For those of you who watched First Friday with Fran during the COVID nightmare, a lot of pool contractors were insisting that associations indemnify, defend, and hold them harm, which makes no sense to me. But so again, if you have a particular issue, you need to talk about it, indemnification. But the default setting is associations should not be indemnifying, defending, and holding harmless anyone. Attorney fee shifting. We generally advise our clients not to agree to attorney fee shifting unless it's one-way attorney fee shifting, in that if the association goes after a vendor for breach, the association can get its attorney fees back. But once the association agrees to attorney fee shifting, it makes it very hard to negotiate a settlement in any type of breach, right? Because the vendor will say, I'm going to go after you and you'll pay my attorney fees. So whenever you see attorney fee shifting, be very careful. Communicate dissatisfaction in writing, make the record. Very often, in our office, we'll have a vendor relationship going on that we know nothing about, and we'll get a phone call on a Friday afternoon at 4, and they'll say, hey, Fran, we need you to send a termination letter to this vendor immediately. They haven't been doing their job. And we say, oh, really? What happened? And they say, well, for the past 5 years, we've been telling them to do their job, and they haven't been doing it. And we go, awesome, that's great. I'm sure you documented, send over all those emails that you sent them, give me all the notices. And they go, we don't have any of that. Right. And I go, okay, now we're awkward. And I said, can you send over a copy of the contract? They send over a copy of the contract. We never were involved in the contract. The contract says termination for cause only, for cause only. And I say, okay, can you tell me about cause again? And they go, like I said, for 5 years, they haven't been performing. So that's really weird. And you've been paying them. Yes, we've been paying them. And you know what happens when the vendor gets our termination letter? They said, we didn't breach anything. We never breached anything. And in fact, it's quite clear that we never breached anything because we've been working for them for 5 years and we never received an email or a letter or anything that says we've been doing a poor job or breaching the agreement. So if you do have a problem, make sure you convey your dissatisfaction in writing and make a record. Okay. Do not hire a replacement contractor until the original contractor is terminated. I know this sounds like basic common sense and nobody on this call would do this, but this has happened to us multiple times, right? We fired the vendor, okay, and we go and hired somebody else. And then we get the phone call saying, Fran, this is so weird. You're going to laugh, but we terminated XYZ vendor and we hired the replacement vendor. And now the first vendor is saying we didn't properly terminate him and he's going to remain on the job. But we already hired a replacement contractor. What should we do? Now you have two contracts. So that's where you get lawyers wrangling and fighting over, well, it was proper termination, it wasn't proper termination, was there fee shifting, et cetera, et cetera. So do not hire a replacement vendor until you're cleanly terminated the existing vendor. Progress payments and retainage. Make sure in your contracts you have a progress payment schedule. Whatever the project happens to be, make sure you know how much the project's going to be, price and payment. How much is it going to be? How much are we going to pay on that? When will be the payments due? And how much shall we retain? Many projects, there will be a retainage of say 10, 15, 20%. And that the retainage is only released after the punch list has been complete. Not just substantial completion, but the actual punch list items have been complete. Driveway paving, roadway paving, roofing, etc. Keep the money if performance has been unsatisfactory. This is brutal for us, as you know, as the lawyers and the managers. This happens to them as well. The board says, hey, you know what? Everything looks good. Pay the vendor. And the check goes out for the final $40,000 payment. And everyone seems happy. And then at the next month's board meeting, the board goes, hey, by the way, this job is so screwed up. And they go, okay, that's fine. We'll have to raise a claim. Where's the $40,000? Oh, well, you told us at last month's meeting to send the final check out for $40,000. You lose tremendous leverage if you don't have a retainage, right? It's very much easier to get someone's attention if you're holding a retainage, right? It's much easier to get people to act if you're holding a retainage. The other wonderful thing about a retainage is oftentimes the manager can deal with a dispute when there's a retainage without having to call the lawyers, right? Because the manager can say, listen, I'm holding 40,000. All you got to do is crack fill the cracks in the clubhouse parking lot that you missed, and we're all good. Okay. Most vendors would be like, oh yeah, I really want that $40,000 released. I'll go and finish up the punch list items. But if you don't have a retainage, a lot of vendors will go click, right? You won't hear back from them. So retainage is important. Bite back if the association has a claim. So if you have a dispute with a contractor, make sure you raise your claim regarding that contractor. Don't just fight over the amount he or she claims is due, because in law in New Jersey, there's something called the entire controversy doctrine that basically says if you're going to have a lawsuit between the parties, you must bring all claims within that single lawsuit involving the same circumstances, or you will lose your claims, right? So there are boards at times who say they don't tell their attorney that they have their own claims. They resolve the dispute over payment to the vendor and they go, hey, now let's sue them. No, that's not the way it works, right? It's generally speaking, if it's a single set of events and the complaints rise out of the same set of events, they have to be brought in the same action. Preserve evidence. This can be really weird, preserving evidence at times. Hey, Fran, how do we do that? Preserve videos if you have videos, preserve pictures if you have pictures. If you have materials, preserve samples of the materials. So we had a case in Lawrenceville years ago where we had to rent a self-storage facility to preserve wood siding that we were taking off the building that had been improperly installed and was defective, right? We saved all samples of that. In the same vein, before you redo vendor's work, you have to make sure you put the vendor on notice of the fact that you have a dispute with him or her, and they can come out and inspect it. Otherwise, they will say you destroyed evidence and your destruction of evidence should be held against you, right? The contractor will say one of two things. Number one, if you had only told me, I would have gladly come back and fixed it. They'll say that, which is oftentimes not true. But they'll also say the other thing. You went out and fixed it, and that should have or could have been done at a third of the price of what you spent. So therefore, I will happily reimburse you for 1/3 of what you spent. You see what I'm saying? So putting the vendor on notice that you're having a problem with gives them the opportunity to cure, number one. And number two, it avoids the issue of destruction of evidence. Okay. Notify the insurance carrier in writing of damage, dispute, or a lawsuit. So again, we talk about this all the time on First Friday with Fran. If there's an issue, if there's a claim, if there's a threat of lawsuit, make sure you put your carrier on notice so that it's not denied based on a failure to provide timely notice. Okay, get signed release and agreement before paying. So if a contractor says, yeah, we're fighting over the final $20,000, listen, I'll be cool if you just give me the $20,000 and we'll go away. Make sure you document that and get a release from the vendor. The next point is important. Do not release contractors where risk remains. And I have a note there, manufactured disputes. So for example, you have a 30 building roof replacement job and there's a dispute. So you're that 30 roof job, I'm just making this up. It's going to cost you $5 million. $5 million job. There's a dispute over the last $20,000 and who should pay what, and who and when it should be paid, et cetera. And the vendor says, I'm going to sue you. I want that last $20,000. And there's some disputes in the association. There's some punch lists, there's some nail pops, this and that and the other thing. And the association says, you know what? Let's move on. I'll pay you the $20,000. But we're going to need a release. And the vendor goes, yeah, that's fine. I'll agree to that. But we want a mutual release. A mutual release. You don't want to, you as the association do not want to release that vendor, right? And the reason for that is, since you have done so much work, it's a substantial project, you may not see a major structural defect in that roofing work until a year later, okay? Until 2 years later. There may be warranties that you're releasing. So when I say a manufactured dispute, and this is extremely rare, but you just have to be aware of it, I believe that there are some vendors who at the end of a job will manufacture a dispute just so that they can negotiate a mutual release. I know that sounds far-fetched, but I have been involved with vendors where I really feel that. So recently, for example, this is awful, but I was contacted by an association in Somerset County who said, hey, we would like you to represent us in a transition case. And I said, that's fine, we can talk about it. He said, we have a very small community, and I really just want you to look at the proposed transition release agreement. I said, okay, shoot it over. I'll look at it and I'll see if we can work together. And he sent it over, and I think it was like $3,000 was the proposed release agreement that the sponsor was going to pay to the association. And I called the guy back and I said, what is this about? Why would you accept $3,000? He said, well, we don't really know of any problems right now, and everything looks good, so we're going to take the $3,000 and sign the release. I said, no, there's no release in the world to a developer that's worth $3,000. Just ignore it. Throw the proposed release in the trash. Yeah, you're not going to get the 3,000 bucks, but if 2 years from now you find out there are sinkholes all over your roadway, you will still have a claim. If you take this 3,000 bucks, he's gone, right? You've executed a release for a nominal sum, and now you have released many potential issues. Okay. Um, so that was really quick. That was really quick. Sorry if I was talking too fast. I know there are a bunch of questions. Let's jump in there. Where are we here? Got it. For low regular maintenance work, where you use the same vendor for most of all, is it good and worth it to have a master blanket contract with those vendors, which covers, I love that idea. Yeah, so thanks, Jim. Jim has mentioned, so if you have low risk, low dollar issues with ongoing basis with a vendor, thanks, Jim. Should we just have a blanket, or some people call it a master contract? That's a great idea that specify the basic terms for everything. Mike, you want to take one from Al?
Yeah, shouldn't performance bonds be included in any contract? So Al, typically not. The cost of a performance bond would be passed along to the association. So they're used typically in mid and high rise buildings where they're very high value contracts, and there's a chance that the vendor could disappear, file bankruptcy, in which case you would have to pull the bond. But your typical contracts usually would not include bonds. It just would increase the price and add little benefit to the association.
Yep. So Mike says, Mike Lito says, is hiring a project manager working for the association the way to go to oversee a major project construction initiative? Yes. So Mike, I didn't talk about that today. If you're doing a significant project, you should have somebody hired to project manage it. So project management is a generic term. So generally speaking, management companies do not project manage um, significant jobs. They may administer it, and that may be an additional cost. So they may do things like rearrange the parking during the staging of the siding replacement. They may send out notices to the homeowners. They may open and close work areas for the vendors when they show up, but they're not checking whether the roof shingles are installed properly. They're not checking whether the structural beams are secured properly. So, Mike, to your point, you should definitely hire a project manager for doing significant jobs. Now, saying that, you should also be careful as to defining what you expect of the project manager. And the reason I say that is we have had, not too often, but we have had, hey, Fran, we're paying $1 bazillion to have XYZ company project manage our job. And there's a dude sleeping in the parking lot in a beat up pickup truck, right? You don't want that, right? That's not project management. And you don't want to be paying for a ton of money, especially in a world such as today where marijuana is legalized. Right? Because you're going to be having a guy turn his pickup truck into a hot box. So we don't want that. So you have to make sure that you and your project manager have an understanding of what the project manager's expectations are and what he will be doing on the job. Will he be visiting every day? Or will he or she be on site all of the time? Will they be just visiting? Will they be taking samples of materials? Will they be documenting with pictures at the various stages of construction? There are various construction monitoring services now. Some of them use AI, where a camera or multi-cameras um, actually video record the entire project from beginning to end. If you go online and look at YouTube, for example, I think there are several of those types of projects where it's really cool. They watch a time lapse of, for example, a professional sports stadium being built over time. Really cool. So depending on the value of your project, you definitely should have project management, and you should specify how intense you want it managed. Hi, Fran. Happy New Year. Thank you. What does a sealed bidding procedure mean? So that's Danita. Thanks, Danita, for attending, and Happy New Year to you too. So sealed bids are kind of like the government bidding process where um, the requests for proposals are sent out. There's an actual deadline in the request for proposal. The specifications are attached. They're required to be returned in an envelope that is sealed on or before a certain date. And none of those sealed envelopes are opened by management or an individual board member until you have the actual bid opening meeting, right? So all you have whatever 3 or 5 envelopes in front of the board, and the board actually opens them in front of everybody. So, and obviously that's an effort to avoid bid rigging, right? You would hope that, that if you did have sealed envelope bidding, and there are even ways, as you might imagine, to rig sealed bidding. It's a way to try and avoid I'm sorry, bid rigging if you can. So that's the bottom line with that. Let's see. Oh, Al mentioned it. Yeah. Uh, let's see. So Al just described it as builds are opened at the same time once they have been reached a deadline for submission. Right. Thanks, Al. Is it normal to issue a statement of work after contract proposal and bids have been received and request a quote for the statement of work? So Bill, I haven't used the term statement of work before. I mean, it depends, I guess, how big your project is. On very large projects that I'm involved in, I track through a modified AIA. Um, they call them project families or contract families. So it really depends. So in certain public bidding scenarios, the proposal request for proposals goes out with the specifications. Before there is even a bid submission, they have what's called a bidders meeting, and there's different terms for that. They have a bidders meeting so that the bidders can come in all together and they all hear the same shtick, or they can all ask a question. Hey, I saw in the specification that this was weird, but I'm not super familiar with the statement of work term there, Bill. There are there are more and less complicated um, procedures, and there are ones that even involve, you probably know this, more than this, where you have to submit shop drawings as part of the bidding process. You have to submit additional materials as part of the bidding process. You have to submit a bid bond. You have to submit a performance bond. So really, it depends on how crazy the project gets. Doing road paving where costs are 600K plus is where I felt performance bonds should be used. So Al, you can, and this may go to Bill's question a little bit too. If you get up and over 600,000, you can insist on performance bonds or bid bonds. The issue there though is you just pay for them. That's all. But so you can have bonded. The funny thing about bonding, I'm not a big fan of bonding. Like bonding, I'm sorry, like insurance, uh, bonding companies are in the business of collecting money and keeping it rather than paying out. So a lot of associations have the false belief that if we have a bond, it's going to be no problem. The guy doesn't perform. We're going to turn to the bonding company, say, hey, he didn't perform. Give us our money. That's not been my experience with bonding companies. The bonding company says, well, not really. I mean, he seems like he performed. Show us that he didn't perform. And it winds up almost turning with a lawsuit to a lawsuit within a lawsuit. And you wind up having to go after the bonding company. Mike Polito, I think, was on before. I don't know if he still is, but it's an issue in transition all of the time because even though developers post bonds with townships and municipalities, that doesn't mean that the township's going to call those bonds and make performance happen, right? Because bonding companies just don't automatically pay out. Um, Bill Ferguson, if you want to offline, shoot me an email about that statement of work. I'll be happy to look at it. Um, that was it. Wow, that was quick. If anyone has any more questions, let me know. But if not, Danita, did you have another question? You good? Oh, she's good. Okay. All right. Well, it's that was quick, I know. But again, Happy New Year. I'm really glad you're all here. I'm sorry it's so cold. I would have arranged for better weather. but hopefully we won't get too much snow, if any, over the weekend. But like I said, it's great seeing everybody, and hope to see you next month.